Good morning, everybody. My name is Elizabeth Beattie, and welcome to the Harris & Clark Rickaby's Essential Updates from In-House Lawyers. I'm your chair for this morning. We've got a lot of people joining us today, and it's going to take a minute or two for them all to be admitted to this meeting. So I'm just going to, if you don't mind, we'll just hold on a minute or so, just until everybody is with us. As we are for the first time running our autumn conference remotely, it gives us an advantage of being able to reach out to a greater number, but at the same time, we are at risk of any potential technical difficulties and glitches that may arise with the virtual meeting. So my apologies in advance if there are any issues. Obviously, if you're struggling to hear us during the course of this seminar, then you do use the chat facility and let us know, and we will do our very best to sort that out for you as quickly as possible. I can see that a number of people are joining us very quickly now, so because we've got expecting over 100 people today, I'm just going to wait a little bit longer before we get going properly with this morning's seminar. I've noticed today, amongst the many people who are joining us, we've got a number of existing friends and contacts and also a number of new faces. So we're really looking forward to the opportunity to catch up with those we already know and to reach out and introduce ourselves to people who we've meeting for the first time today. So I can still see that people are still joining us. I think that we'll less than another minute, and I think we'll be able to properly get going this morning. Right then, so we've managed to admit most people to the meeting now, so I'm going to properly start today's Essential Updates for In-House Lawyers. My name is Elizabeth Beattie. I'm a partner at Harris & Clark Rickaby's, and I'm also the head of the In-House Lawyer Services and your chair for this morning. We've got quite a lot to cram into the next 2 hours, and I hope that you will find this very interesting. We've got a number of different sessions to work through, which I'll explain more in a moment. But before we do so, a little bit of housekeeping to deal with. For those who joined us right at the beginning, while we're waiting for them to connect in, we are running this remotely, obviously. We apologise in advance for any technical glitches there may be. If you are struggling to hear us or any problems experienced during the course of this seminar, please use the chat facility on your screen to let us know, and we'll do our very best to sort that out as soon as possible. You will have joined this meeting with your camera and microphone turned off. I'd ask if you could leave that alone during the presentation from our speakers. Once we're moved to the discussion groups, about halfway through today's seminar, then the cameras and microphones will be turned on. If you have any questions at any stage during today, we will be fielding question and answer sessions after all but one of the presentations. But we will, if we're unable to deal with your questions during the time that we have allocated today, we will ensure that we'll come back to either the speaker will come back to you directly, or we will come back as quickly as possible to make sure we deal with all of your queries. Just to outline the format for today, we are going to start with 2 presentations from my colleagues, and after which I've mentioned we're going to have some question and answer sessions. We're then going to have some breakout discussion groups where we have allocated everybody who's joined us today randomly into groups for an opportunity to have some chance to network with each other and just some general discussion. The presentations this morning are actually going to be recorded, but the discussion groups will not be recorded, and so Chatham House rules apply. So please feel free to raise any issues or discuss whatever's important to you at that time without any fear that it will be recorded. So I think that covers all of the necessary housekeeping. So I think we can actually now start the seminar. And so the first speaker this morning is my colleague, Georgia Shrine, who's a senior associate in our commercial department. And she's an expert in relation to data protection law and the GDPR. And she's going to provide you an update on the GDPR and in particular looking at what's new and how Brexit will affect it and data protection. So Georgia, over to you.
Thank you. I think to start, there's going to be some poll questions and they should be up on your screen. So if you take a moment to read those, the first is, have you appointed a data protection officer, a DPO? Did you vote on that? And the second question is, if you have, is the person internal or external to your business? And our third poll question is, has your business reviewed GDPR in the light of Brexit? So that makes interesting reading. I'm glad to see that people are at least confident about whether they've appointed a DPO or not. There's nobody saying they're unsure, which is nice. The majority of you have an internal DPO. And well over half have reviewed your GDPR in light of Brexit. So that makes interesting reading for me. So let's start on the GDPR and data protection. As Elizabeth has said, we've got a few enjoyable minutes to talk through data protection law this morning. My name's Georgia Shrine and I work in the commercial team at HCR. I'm going to assume you all have a working knowledge of the data protection law, which your poll questions or your poll answers have just confirmed, and that you're familiar with the main provisions of data protection legislation and the Data Protection Act 2018, as well as GDPR, obviously. My aim is to update you today on data protection generally over the last year, and then to shine a light on some of the trickier aspects that might happen post-Brexit. So in 2019, we first saw high-profile judgments under GDPR, famously the British Airways and the Marriott Hotels cases, which both concerned large-scale hacker breaches. Both judgments underlined the obligation on the data controllers to ensure that their IT systems, where they stored their personal data, were secure and that they were regularly updated. And both judgments led to huge fines. These have recently been reduced. I think the ICO has decided that the COVID effect has been brutal on air travel and hotel and leisure industries particularly. And so the fines are slightly more reasonable now. Since then, though, what is new in 2020? Well, my feeling is that in 2020, the ICO has focused perhaps less on the very big high-profile cases and has instead investigated smaller companies, smaller businesses, and really looked at the slightly less glamorous, perhaps, areas, and looked at the compliance in the less high-profile areas of data protection. So what I propose to do is go through some of the recent ICO decisions this year that help us all to identify possible areas of risk in our own businesses. If we start in March, that saw the beginning of ICO investigations into the conduct of SMS marketing campaigns particularly. The ICO served a large fine, 500,000, on CRDNN Limited, who were a lead generator business. And I have seen similar throughout a number of industries, particularly in this lead generator business, where they made 193 million automated calls without the consent of the owners. And these were obviously then, that's a large number of nuisance calls to have made. Why I mention this is to remind us of the connection between PECA and GDPR and the requirement of consent that flows through both, and the fact that the ICO don't just enforce data protection, but also PECA in terms of marketing. If we look on to July, a number of European supervisory authorities started investigating the platform TikTok, who were liberally helping themselves to young persons' data that had been uploaded onto their platform. I'm sure you're all aware of what TikTok is. This investigation at the moment has stalled a little because TikTok have taken steps to reorganize internally and have created a base in Dublin so that really any inquiries have to go through the Dublin office now, and that has changed the pattern of the investigation. The focus there, though, really is on a little talked about area of data protection so far, which is how we protect children or young people online. And I will be coming back to that in a few minutes. Moving on to August, we were treated by the ICO investigation to an old style scam by fraudsters who had hacked into the Ritz restaurant reservation booking system, taken client numbers, and then they got on the phone and they tried to persuade these clients to give them the credit card numbers. In a way, I think the premise was that they needed to prepay or pre-book or something like that. In one case, the fraudsters then tried to spend thousands in Argos, but they weren't very successful. I think that was reported, and that led to them being caught. They, of course, face criminal penalties for their fraud, but the Ritz was investigated for the data breach. And that itself serves as a bit of a reminder to us all that data protection is not just about big data, large-scale electronic data. It can also apply to small volumes of personal data and to handwritten records. In this case, of course, the Ritz was not a handwritten record, but it would apply in the same way. In October, we had the H&M case, which was an employment case where employee records were scrutinized by the supervisory authority. This was a German case. The same applies, though, in the UK as well. On scrutiny, it was held that the employee records were too personal and represented an intrusion into their private life that wasn't necessary on their HR record. So what was happening was the supervisor was having a chatty meeting with their employee, and then without notifying the employee that this was somehow going to be recorded or what the purpose of their discussion was, they then made notes onto the HR record of things like religious festivals that had been celebrated, holidays that had been taken, not the number of holiday days, but where they had been, for example. And this was then consulted again when it came to considering opportunities for promotion or other abilities of the employee. What happened was that the affected employees all received a large compensation payout from H&M, so it was expensive. It was also incredibly embarrassing to H&M, and they pledged to review their processes and reshuffle their management. So the lesson to us all here is obviously to ensure that our HR teams are properly trained and are aware of how to keep appropriate records of relevant personal data. It's also a reminder of the general data principle that only strictly necessary personal data should be kept, and it should be kept for as short a time as possible. Most recently in November, a law firm was fined £10,000 because they accidentally disclosed some personal data. They sent letters to the wrong address, I think. And the fine seems disproportionate to the disclosure of a small amount of personal data. And that is because when they were then investigated by the ICO, they did not cooperate, and they also had failed to report their breach. I mention this now not because it's a law firm and we're all lawyers, but because it is important to remember there is a duty to report a breach, and of course, to cooperate if the ICO come knocking. Certainly would have fined them less had they cooperated. Finally, I'm going to mention on this slide the ICO bid to prevent political misuse of personal data in the UK. This has been a recent report by the ICO on how political parties in the UK collect and process personal data. And their report has made recommendations to the 7 main political parties to improve their collection and use of personal data, which has been collected in many different ways, on the doorstep, electronically, all sorts of ways. ICO thereby shutting the stable door after the Cambridge Analytica horses bolted. To me, this year's ICO investigations indicates this trickle-down effect. Data protection is no longer just about big data and big IT security systems. but they're looking at all aspects of the GDPR process and all sizes of establishments. Can I have the next slide, please? It hasn't just been the little things, though, this year. There's also been an important twist to the matter of data transfers. In July, the European Court finally ruled on the Schrems II case, holding that the Privacy Shield does not provide an equivalent protection to the GDPR, and therefore transfers of personal data made from the EEA to the US using Privacy Shield can no longer be seen as compliant with the GDPR. This is based on the idea that the GDPR provides absolute security of personal data, even from governmental surveillance. And the idea that the domestic law in the US allows public authorities to monitor personal data regularly, all data, even that transferred into the US for national security purposes, goes against the principles. As Privacy Shield has not got an inbuilt protection for EEA personal data, it's held to fall short of the standards of protection and therefore isn't compliant. While examining Privacy Shield, the European Court also commented that the standard contractual clauses and the binding corporate rules that one might alternatively use would in all likelihood also fall short for the same reason. They do not have primacy over US government rights to enforce national security measures. So that has left us with a big hole where Privacy Shield used to be, and we have nothing to plug it with. Although, at the moment, there are talks ongoing, apparently, between the US and the EU Commission to see how Privacy Shield could be adapted to become GDPR compliant. There has been a joint statement of that. As far as I know, there hasn't been any progress. So at the moment, the only fully compliant way to transfer EEA data, personal data that is, of course, to the US is either with the data subject's explicit informed consent or on the basis of another Article 49 derogation. Just as a reminder, specific consent, of course, is consent that the personal data subject gives to the transfer of specific personal data for the particular purposes that are given and into a territory where the data subject has been told that it does not afford the same protections. Just as a reminder, though, as well, standard contractual clauses and binding corporate rules are not generally invalid, of course. They're still reliable as a means of transferring personal data into third country territories, provided that the controller assesses all the context and risk involved. So we'll talk more about that in a moment. Also on this slide, this year, we have had the introduction of the Children's Code into the UK that was launched in January and is now in force from October. It's important to all providers of platforms that deal particularly with young children or that appeal to under 18s. It's interesting here that we've gone for the under 18 bracket because the GDPR itself talks about under 13-year-olds and under 16-year-olds, but this is UK legislation and it applies to under 18s. It would, of course, come back to that TikTok example that I was mentioning earlier. The Children's Code is a 15-point code that is aimed at building in protections to those platforms that are used by under 18s. And it really relies on the platform provider assessing the risks that are involved and that they are to review those platforms individually. It will then obviously also be enforced by the ICO. Finally, another case that has been in the spotlight this year is the case of Leeds and Lloyds Bank, where the court considered the point of repetitive subject access requests. And in this case, it was interesting because the court decided that it did have a discretion as to whether or not it had to order compliance with a subject access request for a start. And in this case, it then held that these requests were repetitive to the point of abusive, and therefore they would not order compliance. The court also remarked that the use of these repeat access requests was disingenuous. It was not in order to obtain particular personal data, it was actually being used as a means of extending discovery in pre-litigation to gather evidence against the bank. So the court had dual reasons. One was the nature of the repetitive, verging on abusive access requests, and the other was that there was a collateral reason. I mention it here because this does offer some support for businesses who decide that for repeat requests they are going to charge, or maybe even refuse where they suspect that the request isn't genuine and that it is bordering now on excessive and abusive. May I have my final slide, please? So this is where we get to the post-Brexit bit. UK as a third country. So in respect of the end of the transition period, which obviously is coming very soon in about a month, and from the 1st of January 2021, the UK will officially be a third country in all respects with the EU, but of course, particularly now looking at data. From the UK point of view, we already have a decision that the government here is going to treat all transfers into the European Union as adequate, and there are no further requirements made. So if we want to transfer UK gathered personal data into the EEA, we can continue to do so in compliance with the Data Protection Act 2018, subject only to a data processing agreement recording the details of the data processing. The other way around is not quite so simple though, and the UK government has already made a request for an adequacy ruling. That seems very unlikely to be coming before January, and in fact may take longer because traditionally adequacy rulings do involve an investigation of the data protection processes and procedures in the country. Obviously, we are very close to the GDPR and in fact rely entirely on it. So strictly speaking, we should be in receipt of an adequacy decision. We'll see when that comes. If we do get the adequacy decision, what does that mean? Well, it means that the whole territory of the UK is deemed to be a safe environment for the EEA to transfer data to. And it means that those data transfers can continue based only on a data processing agreement, the so-called model clauses that we're already using to record our data processing activities. If we don't get an adequacy decision, or until we do get an adequacy decision, the UK is a third country, and any transfer of personal data out from the EEA to the UK becomes a restricted transfer. And that can be undertaken, obviously, by the EEA-based controller if they use additional measures, which are our favourite binding corporate rules and our standard contractual clauses. This is an obligation that is placed primarily on the EEA-based controller, though. And in the UK, we will find ourselves under pressure to comply because otherwise we won't be able to receive that data. The BCRs and SCCs, so our binding corporate rules and standard contractual clauses, effectively impose the same security measures that the GDPR already imposes, or that an adequacy decision would agree on or benefit us with. To coincide with Brexit neatly, new draft standard contractual clauses have just recently been issued by the European Commission. These were issued on the 12th of November, and they're in consultation until the 10th of December. There will then be a grace period if they are finalised, and we have 1 year to put these in place once they are finalised. So that would mean replacing existing standard contractual clauses and of course using them going forwards. The new standard contractual clauses are slightly different to the existing ones. Obviously the existing ones were already drafted in 2010 and therefore never entirely general data protection regulation compliant. And the new ones are slightly drafted with a view to the Schrems ruling as well, and they require that exporters of data conduct what is called a transfer impact assessment. And this is a relatively new point to be emphasizing. That requires that a data exporter needs to ask questions such as, what effect or impact will the transfer of this personal data into the third country have? Do I still have the control of it? And can the data controller make that transfer, knowing that the principles of the GDPR will be adhered to? If we apply that to, say, the US data transfers and the Privacy Shield issues, then the question would have to be, do the new standard contractual clauses prevent the primacy of the general governmental right to surveil electronic transmissions? And to me, the answer remains no. So I am not sure that the SCCs will help us plug the Privacy Shield gap, but they will certainly update the existing agreements, making them more GDPR compliant and help us in our Brexiting. The new format of the SCCs are likely to come into force during 2021 after the consultation period, but you should be aware that there may be change in that because it is still the consultation period. Another point to mention considering Brexit is the direct contact that a UK-based business might have with individual customers and suppliers or other agents and workers in the EEA. And for that purpose, and I've already mentioned this in previous talks, we would need to consider, do we have an establishment in one of the territories in the EEA where the data subjects are located, or do you need to appoint a local Article 27 representative in the EEA? Only one of these Article 27 representatives is required throughout the EEA, but it must be located, this representative, in a territory where the personal data subjects are. There is a possibility that this will be revised and that will need local representatives in each territory. This seems to be something that's under discussion at the moment. The thinking behind this, of course, is the protection of the individual data subject's rights and the ease of enforcement of the GDPR directly in the territory. A final word on the coexistence of the Data Protection Act 2018 and the GDPR. Obviously, the DPA is based on the GDPR and reflects it and must be read in tandem with it. So they both continue to be relevant. This means that for the time being, our national data regime remains very similar, very close, and as strict as the GDPR. So for our own transfers of data to the US or to other countries, we need to carefully scrutinize what additional security considerations we need to put in place. In addition, we need to carefully monitor export of data from the EEA to the UK going forward so that it complies with the GDPR. There's been discussion about the freeing up of data flow in the UK, and we'll have to see how that develops. So we also need to remember that the GDPR and the DPA can now develop away from each other independently from both perspectives. Thank you, and I'll pass you back to Elizabeth now if you've got any questions.
So again, thank you, Georgia, for a very useful session this morning on GDPR and data protection. I think now what we're going to do is to hand over to my colleague, Ruth Sherratt, in our regulatory team, who's going to talk to you today about the key issues in health and safety now and addressing the risks both in the workplace and at home. Ruth, over to you.
Thanks very much, Elizabeth. Now, what on earth could a health and safety lawyer talk about this year? Well, anybody who came to the last year's conference and previous conferences will remember that we usually try to engage your attention by talking about the latest health and safety statistics. This year, the statistics released are that 111 people died at work and over 65,000 injuries were reported under the RIDDLE scheme. Might talk to you about enforcement and enforcement letters, prohibition notices, improvement notices, the fact that the HSE always charge you to investigate you, the prosecutions that we've had, the cocky contractors who walk across building roofs and fall through fragile roofs, or build walls that collapse, or employers who let their employees just override safety systems such that power presses squash them. I could engage you with gory details. What have I got this year? If I could have the first slide, please. Yeah. The most terrifying workplace scenario you could possibly imagine in 2020. Of course, I'm talking about the C word, COVID-19, and how it's affected everybody. The first thing you might think is, this is just a worldwide pandemic. It's everywhere, it's in the atmosphere, we can't see it. How on earth is this a health and safety at work issue? It's just not fair to make employers responsible for a worldwide pandemic. And there is a lot of sympathy with that argument. As lawyers, you might particularly be thinking, well, hang on a minute, all these restrictions that we've had, they've all been imposed under the Public Health Act 1984. They've not been imposed under the Health and Safety at Work Act 1974. And besides, how would you ever prove somebody caught the disease at work? Health and safety only applies to work. It doesn't apply at home. It doesn't apply in your private life. What I do in my own home is my business. I'm with you all the way. And to be honest, at the start of the pandemic, frankly, even the HSE was a bit quiet. They kept their heads down. They just directed everybody to the Public Health England website. They didn't issue any guidance at all to employers to start with. Then there was a lot of questions about, should employers be reporting COVID cases at work to the HSE under the RIDDOR scheme? And there was a lot of scratching of heads as to whether the HSE, Health and Safety at Work Act, did cover it. And finally, the HSE issued a guidance saying, well, if you've been handling the virus in a sort of laboratory setting and somebody catches it, then yeah, tell us about it. But otherwise, we don't want to hear about it. There's far too many cases. They're never going to deal with them all anyway. So don't bother telling us about that. It's only where you're handling the virus. Then the next guidance seemed to come from the Department for Business, Energy and Industrial Strategy, when they were talking about how to set up for the return to work towards the end of the first lockdown. And they were saying, have your COVID secure workplaces, set up your risk assessments. And it was all coming from the government rather than the HSE. And of course, at that time, we had the police and the local authorities enforcing the lockdown restrictions. It was the police who got all the flack about you're following walkers in the Derbyshire moors with helicopters, and local authorities marching around, closing down premises, this, that, and the other. And of course, the coronavirus restrictions were being churned out at breakneck speed. When I checked yesterday, we were on health protection, coronavirus restrictions, amendments, regulations, England, Wales, Northern Ireland, whatever, number 1,331. So at my calculation, we've had 65 new regulations every day since the start of the first lockdown. So it's almost impossible to keep up with what's going on. And so you can almost see why the HSE have slightly given employers a bit of an easy ride so far. First of all, there was nobody at work for 3 months, but now things are starting to move. Finally, the HSE seems to have been issued with a playbook, and they have started to issue improvement notices for COVID secure workplaces. One of the first improvement notices that was issued was, in fact, on the government. I'd like to think this is the health and safety executive with a bit of a sense of humour, but I fear not. In fact, the photograph on your screens is of Quarry House, which is one of the sites of the Department for Work and Pensions. And that photograph was taken on a health and safety inspector's walk around. And it's a scene that, frankly, we still see in open plan offices today. People aren't standing very close together, but they are standing reasonably close together. And it was just a snap. If you could show the next slide, please, Amelia. This is another photograph taken by the health and safety inspector. And again, we're familiar with those pictures, you know, slightly empty desks, bit of a gap between cabinets, a bit of a walkway. You know, it doesn't seem so bad. In fact, what had happened was the DWP had performed their risk assessment. They had come up with a plan for 50% occupancy rate. They had arranged for staggered work. They'd instituted social distancing. They'd put down markers. They'd encouraged their staff. They consulted the union. The Union for Government Staff is the Public and Commercial Services Union. And they pretty much tried their best to do everything that they were told to do. All the stuff in the COVID secure guidance that the government had issued, they'd had a good stab at it. Unfortunately, they had a couple of employees who got COVID. We don't know if it was in the workplace or not, but there were 2 employees who caught COVID. And those cases weren't RIDDOR reported. So it wasn't a question of the HSE going in because they were RIDDOR reported. They were reported because of a workplace concern, which, as we all know, is really an employee snitching. Anyway, the HSE inspector turned up on the 27th of August, and he took these photographs and he had a wander around and he was not happy. So he issued one of those improvement notices I mentioned at the start, and said that in his opinion, the DWP was in breach of sections 2 and 3 of the Health and Safety at Work Act 1974. And I'm sure I don't need to remind you, section 2 is ensuring the safety of your workers. Section 3 is ensuring the safety of people affected by your business. So in this case, it was agency workers within the DWP building. So the improvement notice said, the DWP has not, where possible, maintained social distancing, i.e. introduced measures to allow employees to stay 2 meters apart. The HSE gave credit to the DWP for having produced a general risk assessment, having produced a site-specific risk assessment, having produced a prompt sheet, and having produced a physical social distancing user guide. But they said, your aim of a 50% occupancy rate is unrealistic and ambitious. They had got some information from workers on the shop floor that more and more workers were coming in because they were being trained to deal with all the benefits claims and all the other things that the DWP has to do. And the kind of on the ground evidence was this is getting busier and busier. The HSE inspector was particularly bothered about access and egress points, people coming in all together at the same time, as is normal, movement around the building, going to get your coat from a coat rack, gathering on stairwells. They also said that managers weren't leading by example, that the photograph on the first slide was actually of apparently a manager giving you some instructions to some workers. It may have only lasted 30 seconds, a minute, but the health and safety inspector got his photograph, got his evidence, enough for him to issue an improvement notice. Now, normally, even if I'm attending a client and they've had an accident or something and we're expecting an improvement notice in the post, it's all I can do to get my clients to look out for improvement notices that are coming in the post. Suddenly, it's national news. The BBC carried this story. Now, whether the BBC were carrying it just out of a general pandemic interest, I don't know. But it seems to me that for an improvement notice issued by the HSE on the DWP to make national news, a lot of workers have picked up on that. Now, my main message is, like Santa and his reindeer, the HSE are now coming. They've got their act together. They've worked out that they reckon they can apply the Health and Safety at Work Act to the COVID situation. Now, whatever legal arguments we've got, and believe me, I've worked at quite a few, let's be practical. We're in a pandemic. Let's play, if you pardon the pun, play it safe. So go back after this session, go back to your workplaces and have a think, is our workplace truly as COVID secure as we can reasonably practically make it? Have a look at the HSE website, have a look at the Public Health England website. You'll all have done a COVID risk assessment, I am sure, but check it, give a walk round, march about the place, have another think about it. Record your review now, because records, as we know, are good evidence. Ensure that your social distancing is being enforced. Just like the employer who lets his employees override a safety mechanism, don't let everybody just ignore social distancing. At the same time, be aware of other employee aspects, and I'll come on to those in a minute, but there has to be some leadership by example. And as the HSE has announced they're doing spot checks by telephone as well as in person, have a think about how you would handle an HSE inspection. If the HSE is going to be ringing up the receptionist, is the receptionist primed, ready to deal with an inquiry? Does the receptionist understand that there is no such thing as an off-the-record conversation with the HSE? Make them pass the call to somebody who is trained, who can handle the call. Then have a think about, what if the HSE turns up unexpectedly? They can do, they're allowed to, within reason. They can't turn up at 8 o'clock in the morning when you don't open till 9, but frankly, they're not going to do that. They're going to turn up at 11 when everyone's stopped for a coffee and they're all congregating in the kitchen. Remember all those extra powers that the HSE has and the local authorities have above the police. They can force you to talk. They can take stuff that you need for your work if they feel it's necessary. Then think, if the worst case happens, how would we deal with an improvement notice? The DWP just rolled over and said, right, we'll fix everything. And you can kind of understand it given the politics of the situation. But this is where all my legal arguments come into play. Is the improvement notice really justified? Do you have a reasonably practicable defence? Can you say that we've done as much as we possibly can? If we go any further than this, we've got no business. Have a think about what particular defence you could put forward. If you think it's justified, then fix it quick. Persuade the HSE to withdraw it. It is possible. If you think it's totally unjustified and you want to fight it, then get your appeal in quick. There's a 21-day cutoff for appeals. It is almost impossible to get that extended. It's because it comes from the Employment Appeal Tribunal's rules. It's nothing to do with the Health and Safety at Work Act. This is, as I say, this is where I get my legal arguments into play. I just can't wait for a client with enough money and enough reason to fight it to argue these points, because there is a lot of legal stuff in this, but of course that makes it expensive. The other thing to remember, whether you decide to fight an improvement notice or not, is have a think about your industrial relations. and potentially publicity as well. You've got to keep your staff happy as well as keeping them safe. I mean, happy in the sense of, you can't, by making them safe from COVID, create a risk of mental health issues. You've got to balance all these risks together. Another thing is that with so much information and frankly disinformation about COVID, you are going to get some staff who are disgruntled and who might snitch to the HSE or the local authority, or worse. The other improvement notice that I've come across was actually served on one of the companies that is doing the testing for COVID. So, doing a worthwhile job, testing swabs, dealing with the virus itself. A scientist went to work there. He was not happy with what he saw. He thought the PPE was inadequate. He thought the handling of the virus samples was inadequate. So he sang to the HSE. The HSE went in and inspected and issued an improvement notice. The improvement notice on that site, the UK Biocide Limited site, that again reached national press, possibly tipped off by the disgruntled scientist. The BBC carried the story, the Independent carried the story. In fact, UK Biocide Limited at one point denied they'd received an improvement notice, but I'm not quite sure whether it was before or after they were forced to issue a formal public statement saying, well, actually, we have had some observations from the HSE. But because they were sort of denied it at the time, the BBC said they haven't had I beg your pardon, the Independent said they haven't had an improvement notice. The disgruntled scientist, so anxious was he went off and did a FOIA request and got hold of the improvement notices, and there were 2 of them issued against UK Biocide. And the weird thing is that the improvement notices had nothing to do with his concerns about PPE and about handling of the virus. It was almost word for word what the HSE had said to the DWP. It was sort of the easy route of having a pop at their social distancing and having their go at their inadequate risk assessments and so on. In fact, the improvement notice that I've seen actually says, we have not considered the handling of the virus. We have not considered your work, it's just what's happening at your work. So that is bad publicity for that company. So it's something that we need, you need to bear in mind if you are thinking of fighting the HSE on these things. If I could have the next slide, please. And at the risk of another pun, Wales is not such a distant country, but they have done things differently there. During the fire break, they instituted a slightly different regime to the one we've seen in England. And I'm mentioning it now because I'm wondering if we are going to see this in the next set of regulations that we have in England. They had their own regulations, the health protection coronavirus restrictions, brackets number 3, brackets, Wales, brackets regulations 2020. And those regulations sort of combined health and safety regulations and the public health aspects as well. So rather than, as we have in England with lockdown, you have fines and businesses who open and during lockdown, they just get an automatic fine, whether or not they cite the Magna Carta. Then in Wales, they had a specific regulation saying that at any point of work, any place where work is carried out, the persons responsible for the premises must do 3 things. They must take reasonable measures to maintain social distancing, take other reasonable measures to minimize the risk of exposure to coronavirus. So that's hygiene, face washing, so face masks and so forth. And they must provide information to those entering the premises. Now, as I said, in England, where we had fixed notices, in Wales, they had introduced a system of improvement notices and closure notices, basically prohibition notices. So in Wales, they would shut you down for up to 14 days, but they could also issue this improvement notice, similar to a Health and Safety at Work Act improvement notice. But in Wales, you could only appeal it within 7 days to a magistrate, and it didn't automatically suspend the improvement notice. So not surprisingly, I don't suppose many were appealed, but there was certainly an awful lot of improvement notices issued, which would no doubt leave businesses sort of reeling, and what do I do with this? What do I do with this? You know, I've got to fix it. I've got to fix it. There's no chance of questioning it. And, you know, maybe some of them should have been questioned. The reason I mention this is because I think there is scope in the future for improvement notices to be issued on the basis of control of premises rather than protecting the risk of health. That's another section in the Health and Safety at Work Act. I won't bore you with the technicalities now, but I do think that the HSE is getting their heads around this, and we will see more and more improvement notices being issued. As I said, that's working within the workplace. Obviously, with a lot of people are working from home now, and we need to consider the sort of indirect effects of the pandemic on working from home. The first one is obviously, to those of us who are office-based and we're working from home, is ergonomics and sitting at a desk all day and having your display screen equipment. And the HSE generally say, if it's just temporary, you don't need to worry too much about display screen specific regulations, because, you know, eyes won't fatigue if you're just doing it for a short period of time. But generally they're saying, you know, if it's going to be a long time situation, then encourage your employees to do their own workspace risk assessments and so on and so forth. The other aspect is sort of lone working, which ties in with mental health. And that is that with lone working, it can lead to obviously mental health stresses and strains. And the HSE has declared that mental health is one of their key targets. That was obviously before the pandemic, but that will play into their kind of hit list of things to focus on. And so keep engaged with your employees. Also from a point of, you know, keeping them informed, making your employees feel loved, for the want of a better phrase, will avoid those complaints to the HSE, which is where a lot of the HSE inspections come from.
The next presentation is from my colleague, Steve Thomas, who's a partner in our commercial team. And he's going to provide an update for you on Incoterms and thoughts on the impact of Brexit and the key issues when drafting limitation of liability clauses. So Steve, over to you.
Thanks, Elizabeth. Good morning, everyone. Yeah, so I'm Steve Thomas. I'm a partner in the commercial team here at House & Clark Rickabees. We have a team of 15 commercial lawyers, 5 partners, advising clients across a range of issues, contract drafting, data protection provisions, consumer rights, and IP law issues. Could I have the first slide, please, Amelia? So the topics I wanted to talk to you on today are firstly Incoterms. With Brexit 35 days away and no free trade agreement in place with the EU, I think it's fair to say that there's a degree of uncertainty and confusion as to what actually is going to happen on the border between the UK and the EU on the 1st of January, if you're in the business of moving goods backwards and forwards across that border. That I'm sure is going to place a lot of strain on the relationships between customers and suppliers, which we're going to need to work through. I'm sure most of you, or in fact all of you, will be deep into your Brexit planning processes in terms of understanding the impact of Brexit on your businesses and your supply chain. So to a degree that I'm sure you'll be well down the track of considering these issues, but I thought it would be helpful to have to provide some thoughts on Incoterms and some of the impacts, particularly around Brexit. Secondly, no commercial update is complete without some commentary on drafting and negotiating limitation of liability clauses. So I've got a recent case on that and some tips in terms of issues to consider when you're drafting those types of clauses. And finally, I'm going to make some few comments on our commercial team at HCR Flex service proposition, which is a new way of accessing the expertise and services within the commercial team. Can I have the next slide, please, Amelia? Okay, so Incoterms. In terms of whether there's going to be a deal or not, my personal view is I think there's too much to lose on either side for there not to be a deal. So my bet would be that there will be a deal. But I think what's going to be clear already from that is that any deal will be incomplete, and it will be a compromise. And in terms of how a lot of the detail about impacts on the transfer of goods across the UK EU border, I think that the detail of that will only come out over the coming months, and indeed I suspect years. So in that context, I wanted to have a sort of take you through and give you a reminder of Incoterms. I assume people would have heard of the term. So what are they? So they're a common set of rules that traders based in different countries can incorporate in their contracts for the sale of goods. They're published by the International Chamber of Commerce. The first Incoterms were published in 1936, and the latest set, version 9, was published last year. So they've been around a long time, and I think served the test of time. It's important to note that they're not laws. They are standard contractual terms, which, like any contractual term, need to be properly incorporated into the contract. So you need to be careful how you include language in your contract to make sure that they're properly incorporated. What do they deal with? They deal with an allocation of responsibility between buyers and sellers of goods, and in particular, which party has the obligation to arrange transport and insurance of goods, which party will be responsible for the cost of that and any customs duties, at what point delivery is deemed to take place, and when does the risk, but not interestingly, title to the goods passes. What's sort of important to note, and what will be quite obvious, is that's actually quite a narrow set of issues. So it's important to be clear that the Incoterms only deal with a very quite a narrow set of requirements for your sale or purchase contract, and so you need to consider those in the terms of the wider contract. So Incoterms will not deal with when title to the goods pass, price, payment terms, and remedies for breaches. Indeed, there are certainly Incoterms provide for insurance obligations on one of the parties, but generally that's quite simplistic. So often, even if you do have an Incoterm which imposes an insurance obligation on one of the parties, it's worth considering whether that needs to be expanded in more detail in your contract. So they're only part of your contract, part of the solution, part of your contractual documentation, but an important part. Finally, whilst of course they're designed for international contracts of sale, you can use them for UK only contracts. Just change the next slide, please. So there are in fact 11 Incoterms. The 7 that I've listed here are the Incoterms that apply to all modes of transport. There are 4 others that apply to carriage by sea and inland waterways, but these are the key ones, and I thought I'd just put that slide up to illustrate the spectrum of responsibility on the left-hand side, where we're looking at it from a supplier's point of view, being the minimum responsibility, the Ex Works position, where effectively the supplier's obligations and responsibilities are performed by delivering or making the goods available at their factory, all the way through to the other side of the spectrum, DDP. Next slide, please, Amelia. So you often see them obviously expressed in those high-level terms, but I thought this table illustrates the sort of complexity that sits behind that and the different elements of our import-exporting process, which needs to be considered. So there's quite a lot of detail, lower-level detail that you need to be thinking about, that sits beneath this in terms of the different levels of responsibility. Next slide, please. So what's changing? I think the reality is obviously, as I say, quite a lot in terms of practically how things are going to change, getting goods through the border between the EU and the UK. I think pre-Brexit, certainly my sense is that Incoterms have been kind of used fairly freely and perhaps often in a way that doesn't reflect what happens in practice. And in reality, I think contracting parties have not been impacted by that because of the frictionless nature of the transfer of goods between the EU and the UK. So it just hasn't been an issue. That's going to, whether or not we get a free trade agreement, that is going to change dramatically, I think, in January. So what's going to change? I think there will be certainly if we haven't got a free trade agreement, and to a degree, even if we have, there may be customs duties payable on goods passing between the EU and the UK. Both import and export clearance documentation will be required. That flows through to extra compliance costs for the parties and potentially delays on the movement of goods through the border. So things are going to change considerably. These issues will create an additional administrative cost burden, and the parties need to be thinking about that and discussing that with their counterparties now to make sure that they're clear on how those issues will be addressed. And then flowing from that, how you amend or reflect that allocation of risk and a responsibility in your contracts. Next slide, please, Amelia. So I thought it'd be helpful to sort of give this some colour and illustrate it by looking at some of the key terms that are often used, and looking perhaps at the two terms that are either end of that spectrum, Ex Works on the one side and DDP on the other, to give this some context. In my experience, I think there's often a temptation for the counterparties to just go to the either end of that extreme position of the spectrum. And so from a supplier point of view, the supplier's looking at an Ex Works position, which you just make the goods available at their factory and let the customer do all the rest, and DDP being the reverse of that. So I think that's common, but let's just work through that in terms of what that actually means in practice. So let's take a scenario of a Dutch toothpaste manufacturer supplying goods to a distributor in the UK. In this scenario, the toothpaste manufacturer in Holland is maybe thinking Ex Works would be good for them. What does that mean in practice? So ex works means that the customer, the distributor in the UK that's buying the product, becomes both the exporter and the importer. The toothpaste manufacturer makes the goods available in Holland at their factory. From there, it is the distributor in the UK's responsibility to deal with that from that moment on. What that effectively means is they become an exporter of those goods in Holland. So the customer will end up having to complete the export paperwork, clearance paperwork to get the products through the export control at the border, and then pay any import tariffs and duties, and then complete all the import clearance paperwork on the other side. So it's a significant responsibility, and the bottom line is, will a distributor in the UK in that scenario have the capability, the expertise to be able to, in particular, complete the export documentation that's required to get the necessary clearance for the goods to leave the EU. So it is a significant undertaking. My general observation is that it may not, whilst that might look an attractive proposition from the point of view of the Dutch toothpaste manufacturer, what you start to lose is control of some of the process. So often suppliers will want to take control of the transfer of the carriage of the goods to the border, because otherwise what in practice happens is if you're pushing all that responsibility to the other party, then you lose control over that process and the costs associated with it. And those, inevitably over a period of time, those costs will be taken into account in the commercial arrangement. So in that scenario, the distributor might be incurring all those costs, but pushing that down to the back to the manufacturer. Next slide, please. So what's the conclusion? I mean, I think the key point at the moment is, I'm sure a lot of you'll be deep into this process already, but make sure you've reviewed your contracts. Think very carefully about what Incoterm is appropriate. My suggestion to you is it's not always sensible to be at the extremes of that range. Have a sensible conversation with your counterparty on where that burden lies, which is appropriate and relevant in the context of your respective capabilities, expertise, and allocation of risk. And then make sure you think about that in the context of the other provisions of your contract. You'll need to make sure that those issues fit together. Hope that's been helpful on Incoterms. Next slide, please. So, caps on liability, the sort of bane of the lives of a commercial lawyer, something that we come across all the time. I just thought it'd be helpful just to take you through some reminders on that. So, first key point, as you'll all, I'm sure, be aware, when you're looking at B2B caps on liability clauses, there are statutory controls over that, in particular through UCTA. Hopefully this slide is a good way of illustrating that. There's the prohibited exclusions, excluding for liability for death or personal injury, or excluding liability for implied undertakers of title to goods when you're selling goods. I think the key, the tricky bit is the amber section. There's a range of types of exclusions which are acceptable if they're reasonable. And I think that the main one of that is the exclusion of liability for other negligence outside of negligence causing death or personal injury. The fundamental conclusion of that is if you're negotiating a cap on liability clause, almost always you'll be looking to exclude negligence as well. So in all cases, pretty much in practice, you will need to be thinking about reasonableness. Next slide, please. So what does the legislation say itself about it? No, not a huge amount that's terribly helpful. There's a reasonableness is whether it's fair and reasonable to include the term considering what the parties knew at the time the contract was made. And then there's also a provision in 11.4 about to where there's some guidance on what issues should be considered by a party looking to impose a limitation of liability to a specified sum. And the two things that are called out are the resources available to that party to be able to meet the liability being restricted, and insurance. Next slide, please, Amelia. So I just wanted to talk you through, I thought this was an interesting case, 2018 case, just sort of gives them some context of where the court's thinking is on these provisions at the moment. So we have a company, Hall Fire Protection, who supply fire suppression systems. They supplied it to a company called Good Life. Both of the companies of similar size and bargaining position. The supplier provided a clear statement in their quotation that they did not provide for the imposition of any form of damages whatsoever. So the supplier's been clear from the beginning that there's an extensive limitation of liability. The parties entered into a contract for this installation of that system. Lo and behold, a few years later, there's a fire. The system doesn't work particularly effectively, and there's substantial property damage, which the client claims from the supplier. It's interesting to note that actually the claim was strictly brought by the client's insurers under subrogated rights, and I think to a degree that was a factor in how the courts made their decision. Next slide, please. So this is the provision that was in the contract. It's a very broad exclusion of liability for all losses caused to goods, persons, or the like, directly or indirectly resulting from our negligence. So very broad, but there's a small warranty there in terms of replacement free of charge of defective goods. So on the face of it, you think that's wide, and that could be subject to some challenge on the kind of there's no reasonable remedy point. Next slide, please. The Court of Appeal actually upheld that cap on liability provision, which is interesting, despite the fact that despite its breadth. And I think these are the sort of key points that came out of that judgment. The ability to insure was, as the court said, at the heart of the reasonableness issue in this case, and the customer was in the best position to place the necessary insurance. Insurance was absolutely key. Bargaining position was a key, important factor in the court's mind, and the court took the view that the parties were of equal bargaining position, and the supplier had a choice. It wasn't, the customer had a choice. This wasn't the only supplier in the market. The court considered an argument inevitably raised by the customer that this clause effectively provided no remedy or limited remedy, and the court took the view that in these circumstances that was okay, it was reasonable, and the contract needs to be looked at in the round. Next slide, please. So, conclusions on that. There's the four key factors that the Court of Appeal in that case took into account, which are key in all cases: ability to ensure bargaining position of the parties, is there an alternative choice of supply, and the extent of the remedy. I think it's really important to say that clear and unambiguous drafting remains the most important aspect of this, because there definitely has been a trend in recent cases towards upholding terms that are clearly drafted, particularly between equal parties. So the concept of the court, which one sense was the case previously, straining to find clauses unreasonable, I think is much less than it used to be. Will a limitation equal to the contract price always be reasonable? I think you all know the answer to that. Not always. There's no court precedent either way on that. But as I say, I think it appears much more unlikely now that courts will disturb a clear clause agreed between parties of equal bargaining power. Next slide, please. So just quickly, I just wanted to draw your attention to a new product offering from the commercial team. This, I think, has been driven a lot by requests from clients, I guess particularly in this environment where there's quite a lot of stresses and strains on resourcing in in-house teams. So we have a product named called HCR Flex, and broadly speaking, it's a product where would provide access to a named dedicated lawyer for temporary projects and to help you manage peaks in demand. As part of that proposition, we'll be offering substantial discounts from our standard day rate charging. So we're moving to a day rate rather than an hour rate. To get that rate, we'll be looking for a small amount of commitment, a minimum of 2 days per month. So why choose that? I think how do we differentiate that with other propositions in the market? I think a few points. We're committed to really close partner support to your dedicated lawyer, so that we're really keen that you get the benefit of our partner expertise at the same rates. The philosophy that we are encouraging all our lawyers to adopt is that they get to know your business, understand your business, and provide you with much more tailored advice as a result. We're looking to be effectively to provide a service that is proactive rather than reactive, which has always been the issue in part with engaging external lawyers, and finally offering, as the name says, total flexibility. You're not going to be we're not looking for this to be a kind of long-term commitment, just a month-on-month proposition. Well, I hope that's been helpful and informative. I will pass you back to Elizabeth.
Thank you, Steve. It's really, really interesting. We have, as I've sort of flagged up before, we've got time constraints this morning. So whilst I have got a question that was actually sent to us before today's session, it's not in the chat group, I will ask if you could deal with that separately so that we can make sure that we wrap up everything today by 11:30 as planned. But thank you ever so much, Steve. I do appreciate your support. So moving on to the final part of today's seminar, we're going to have more of a discussion piece. This session is going to be headed up by Nicholas Groffman, who's our Head of International, and Michael Stokes, who's our Head of Employment and Immigration. And they're going to provide an update on Brexit and the transition period in relation to rules around employment and immigration, and on latest on international trade. This will be followed by a conversational question and answer session between them. So if you have any questions for them as we go along, again, please do use this chat facility, and we will try and make sure that we can get through as many of those as possible. Nicholas, over to you.
Thank you, Elizabeth. Hello, everyone. You all know about Brexit. We've only got 34 days to go to reach a deal, etc., etc. And I'd be surprised if there's anyone here who hasn't, to some extent, been part of a business that has recalibrated. I mean, you've had 4 years to think about it, right? So businesses typically are way ahead of things like treaty negotiations and government movement. So I'm not going to focus on where we are with negotiations on the EU, partly because I don't know. I'm going to look at our relationships with countries outside the EU, because these have already become closer as a direct result of Brexit, and that's where new opportunities lie. So that's of more interest to, all this stuff about business opportunities. Lawyers typically think, oh, well, that's for the business guy to worry about. We obviously need to know what's good for the business. So to be clear, Brexit has already happened. We're in a transition period under the withdrawal agreement, and that is an international treaty. That transition period ends on 31st of December. So during this period, you've got the UK and the EU negotiating their permanent trade agreement, so-called permanent trade agreement. Of course, it won't be permanent. That's quite possible we don't get a deal. That'd be a shame. It won't be the disaster that was being suggested back in 2016, 2017. We know that now. Now, many of my clients were of the view that the EU is geographically so close and our economies are so intertwined that it is inevitable that it's going to be our biggest trading partner. That view is wrong. Trade with the EU as a proportion of our total trade peaked back in 2002. Based on a projection from 2002 to the present, the EU will account for only 25% of total UK trade by 2047. Now that projection is without free trade agreements with other countries. In fact, we will have free trade agreements, and we've already seen businesses starting to look way beyond the borders of the EU. And this year we've already signed free trade agreements, and a small few of those, including the UK-Japan treaty, are on more favorable terms than the EU equivalent treaty. So the EU-Japan treaty is not as good a deal as the UK now has with Japan. You wouldn't think that from reading British media, but you would know it from reading the treaty itself. Right, so before I go on about these free trade agreements much more, and I don't have much time, I just want to comment on the significance of them, which is underplayed. So on Tuesday, I was in a meeting with the Director of European Affairs at the Confederation of Danish Industry. We were talking about Danish trade with the UK after Brexit. And I mentioned this FTA thing. And he leapt in and said, well, Danish companies would feel that it is worth setting up in the UK just to take advantage of the UK-Japan free trade agreement. Now, I mention that because, not because we're all going to start, I'm talking about dealing with Denmark, I'm mentioning it because that is an outsider's view of the importance of these agreements. And why is that? It's because the Danish digital sector is an important part of its economy. So e-commerce and digital, similarly in terms of proportion to the UK. So we've just negotiated a deal that other people think they can take advantage of. We actually, obviously the FCDO and the DIT, well done to them. Not that they're getting much praise for it. So let's just rattle through some of these free trade agreements. Checking how much time I've got. Ooh, not much. Right, so the ones that have been agreed already. Japan, Switzerland, South Korea, the Southern African Customs Union, which is loads of countries. Then the CARIFORUM trade bloc, Israel, South American countries along the Andes, plus Chile. We have MRAs, that is mutual recognition of standards with USA, Australia, and New Zealand. Then the USA, actually, obviously, that's the big prize that everyone's been talking about, including Boris since 2016. People have said, oh, well, now Biden's in charge, so we're not going to get that. Absolute rubbish. The State Department has already said they're going to speed up those negotiations as part of the transition. Quick one on investment. So investment back and forth between our countries and others. Now, the USA is by far our biggest trading partner, unless you count the EU as a country in itself, which it isn't. But if you look at investment, it's incredible the size of investment that you get from the US. We've got $416 billion worth of trade stock, FDI, from the US, 300 billion from us to the US, and that is only going to increase. China's is massively overstated. There's a huge potential there. They've only got about 3 billion. You compare that with the 400 billion from the US. Now, and I just wanted to conclude really this bit by saying that businesses don't follow free trade agreements. You often talk to business people and they say, well, actually, we follow market opportunities. We're not going to first of all check the FTA and then work out where the best market is from that. You know, obviously you need to know your distributors and supplies, but the opportunities offered by free trade agreements should still be investigated. So thank you. And Michael Stokes, who is Head of Employment, will now talk about immigration, which I know nothing about.
Thank you very much, Nicholas. We've got a solemn duty, Nicholas, to stop talking at 11:27 or the firm won't pay for our practicing certificates. So let's take that seriously. In terms of employment law and Brexit and what's going to happen on the 1st of January when the transition period is over and done with, it's fairly easy to say what's going to change about employment law on that date, because there won't be any changes. It's part of the general retention of existing law, and I'm only going to talk about employment law. That's what I know about. It's as if on the 1st of January nothing has changed. We haven't left the EU, except that for future claims, for matters that arise from the 1st of January onwards, there won't be that recourse to the Court of Justice of the EU. And cases will be judged as if they had taken place prior to the 1st of January next year. So all of the pre-existing European Court of Justice authorities, the UK authorities, legislation that was in place before the turn of the year, the cases will be decided on that basis. And so, for example, if an interesting case on TUPE crops up in January next year, that won't have any effect in the UK courts, not direct effect, not binding effect. It might be interesting and influential in the UK, but it won't bind UK courts and tribunals. So with employment law, it's as if we're living in a house with a separate garden shed. The garden shed is fine, nothing's changing there. That's where we keep unfair dismissal, redundancy rights, all those traditional UK-based employment law rights and obligations. The house itself, though, the foundations have changed. Overnight, the old foundations are gone, the concrete's gone. We've got something that looks like concrete, but we have no idea how long it's going to last. And what that means in practical terms is that UK governments, as advertised and as part of the overall policy of Brexit, the point of Brexit, as far as a lot of people are concerned, the UK Parliament takes back control of all of that employment law, subject to almost no constraints, whereas for the last 30 years, 40 years, nearly 50 years, we've been bound by certain constraints. There won't be those constraints, and hopefully later on during this short session, I can develop some of the ways in which I think the law is going to change in the UK after the 1st of January. But the starting point is nothing is changing, even though the European Communities Act is going to be repealed, and normally all those old pieces of legislation would disappear. Immigration law, which is the other half of my job, and I don't pretend to be an immigration lawyer. I've got actual immigration lawyers in the team to do that work. That, in a sense, isn't changing because that has never stopped changing. Immigration law in the UK is massively political. It's changing on an almost daily basis, and that is going to continue. So no change there, except it's all change. It always is changing. The big issue as far as immigration law is concerned that's brought about by Brexit is, of course, there are going to be 400 or so million new people who, if they want to come to the UK to work, will need a visa, whereas in fact they didn't need that beforehand. I'm leaving aside all the people who by the end of this year have been working, living and working in the UK, who may be able to acquire some form of settled status or pre-settled status. But if they're outside in the EU at the moment and they've never come to work in the UK, they're going to be like the rest of the world. And so that is a big market problem effectively for UK recruiters. If they've been used to recruiting employees from the EU, they're going to have to go through a lot more hoops, and they're going to have to pay attention to the immigration system, the visa system that applies already to non-EU countries. As I say, always happy to deal with immigration questions, but not, I'm grateful to say, during this session. There just isn't time. That's my story. One of the things I wouldn't mind developing later on, and this is a hint to Nicholas, is the way in which UK politics will now be able to play into employment law in the UK and how that's changing because of Brexit. But for the time being, I'm going to turn that round on Nicholas and ask him a question he won't be expecting, which is to do with trade policy generally. What I've noticed, looking as an outsider at the US over the last few years, is that President Trump has routinely treated trade policy, international trade, as a weapon, as a diplomatic and economic weapon. And I'm wondering whether that is likely to start to become a feature again of our economy and our economic outlook around the world. Nicholas, what do you reckon?
Thanks, Michael. A really interesting question. We've tried to separate politics from trade. I think the UK has one of the most open economies ever. And it's only recently that, for example, with investment, we've started to have a foreign investment control regime based on national security. Pretty much every other country in the world has that. So the UK is a late starter with very little expertise. I don't think we have the clout that the United States has to start threatening people with sanctions if they don't agree to behave a certain way, otherwise we won't trade with them. And British business anyway is far too invigorated and adventurous to be restricted by government in that way, except in cases where it's criminal to trade with Iran and certain other countries. Actually, Iran, we've recently relaxed sanctions. So no, I think that if anything, we will increase our engagement with the wider world. And Michael, we have a question in for you.
Oh, no.
Which is from Zahid Hussain relating to the certificates of sponsorship. This seems to be a complicated question, but the question is, how do we determine how many certificates of sponsorship we have? Because Zahid says that we understand the resident market test has been abolished, but is it correct that we do have to apply for a certificate of sponsorship and then we would have to evidence a genuine need for the role and have advertised in 2 places for a minimum of 20 to 28 days, which looks like an extremely technical question to me and the sort of thing you might have to research.
That is a ghastly question to put to the head of employment and immigration law, who's really an employment lawyer. And I'm wondering if there's a Sandeep Dattani in the House who may be able to briefly answer that question. If not, if someone shakes their head at me from headquarters and says no, then I promise on pain of his life that Sandeep will respond to that question within minutes of the end of this.
Michael, sorry, Sandeep's written something here that I can see, I don't know if everyone else can, which is that the sponsor would need to look at their sponsor management system to view the certificates they currently have.
That is correct.
That's why you have an expert immigration lawyer on the call, on the session.
But Michael, what's going to change in the employment law from 1st of January in the UK?
I think it's more a question of the fact that things will be able to change in the future in a way that they haven't been for so long. It's this point about how political is employment law. I've always thought it's a massively political area of law. Governments come in, they change employment law. It's one of the things that makes employment law interesting, difficult, and therefore worth being in if you're a lawyer doing my sort of job. For the last almost 50 years, we've effectively contracted out of having to think about whether some employment policies are good or bad things, because we put it all in the hands of the EU, and we've been party to agreeing the policy, the development of directives that tell us how to have employment law in the UK and around the EU generally. And of course, the big thing that's changing practically with effect from the 1st of January next year is that it's going to be in the hands of the UK. And so that becomes a definite domestic political point for the politicians to argue about, so that laws that have been pretty much set in concrete, using my foundations analogy again, are movable again. So if I pick out just a few quick examples, transfer regulations, TUPE, that's from the Acquired Rights Directive, open season on that. My favourite thing to go, not because I don't like it myself, but because lots of businesses hate it, and I can't understand it very easily, is TUPE in relation to sales from insolvent companies. Hugely complicated. You can see a policy developing there where TUPE will be got rid of, and that's possible now, wasn't possible for years. Collective redundancy consultation, that's from the EU. Lots of businesses hate that. That might get scaled down. The furore about holiday pay, that's pure EU law based on the working time regulations. I think they're vulnerable, certainly. And unpopular rights with employers, the honest ones who will say that they don't like these policies. So I worry about day one maternity rights. And I think that putting a cap on discrimination compensation, that's not at all unlikely. The thing is that government's not publicising anything to do with that at the moment. It's not a good time to do that, and they might have been busy doing other things for the last 9 or 10 months. What about on the trade side of things? I mean, the idea of the diplomatic trade war not really being our thing. Domestically, though, that's obviously going to become a political thing within the UK, isn't it? Trade policy generally. Whether to make deals with other parties and how we're back to sort of free trade and tariff reform 100 years ago.
Yes. Well, if we're talking about, who do we have free trade agreements with? I think there are very few countries that we are not trying to create some sort of free trade agreement with. And we haven't done it in sort of order of GDP. The Foreign Office staff and the DIT people are working on everyone. Now, the US is a massive priority, but it's also one of the difficult ones. But the good news is we are viewed by the United States, by the State Department and the Department of Commerce as being easier to deal with than the European Union, and exactly the same response from China. So this, going back to 2016 again, as soon as we left the European Union, China viewed that as an opportunity to try and have a free trade agreement with us, which we didn't take. Obviously, we were restricted during that period on who we could talk to openly about free trade discussions. But there was that desire there, and there's probably a wrong conception from China that we would be, because we're in a weaker position economically, therefore we'd be desperate to sign up to these arrangements. Now that hasn't happened. And domestically, I don't think there is a need to consult, you see. So this is why the FCO, the FCDO and so on have a free hand to do this. There's no need to consult with the wider British population about whether or not we sign a deal with someone else, because this has been the subject of propaganda in its favour for such a long time. So I think there are very few people who say, well, we shouldn't have a deal with these people. But I'm not, sorry, Michael, I'm not sure if that's what you were getting.
No, that's interesting. But I know that you're an optimist about all this. You're thinking that these are big opportunities for businesses, for trading organisations generally. What are any tripwires, anything they need to look out for with this non-EU trade in the future?
Yes, absolutely. So I think countries outside the EU are massively underrepresented in our trade balance. But although that situation has been improved recently as people get to grips with it, and that's really a due diligence question. Companies that have dealt with countries like China often sign contracts, and many lawyers think contracts are more important than investigations. And I would say, if you've got a budget, spend it on investigation due diligence rather than contract drafting, because contracts are difficult to enforce outside the Anglosphere and the European Union. But you need to know your partner, and that requires hard work, investigating and diligencing.
That's interesting, because we had Steve Thomas on mute all the way through that, and he's not allowed to unmute to argue that drafting commercial contracts is more important than due diligence on your trading partners. I think...
thank you, Nicholas.
Yes. No, keep away, Steve, you're off. I'm going to hand back now to Elizabeth, because I think we're right on time now. Thanks very much, Nicholas.
Michael and Nicholas, thank you very much for your comments in relation to international trade and employment and immigration. And also a thank you to Sandeep as well for jumping in and fielding that question very well and ably for Michael. So we now come to the end of this morning's seminar. I do hope that you've found it useful, and thank you very much for joining us. What we'll do in the next few days is follow up with a link where we will request some feedback, and I would be grateful for feedback, both anything good and bad, and also on any future topics that you would like us to address. There'll also be a certificate of attendance provided for you to claim your CPD for attending this seminar, and then there will also follow a recording of the main presentations, so that you can either watch this again at your own leisure, or alternatively you can share it with your colleagues at the office. So it's the first time we've held such a large a seminar by remotely. I think it's been a success, and I do hope that you found it useful. I hope to see you all again. Probably we will continue with some virtual seminars, but also again see some of you in person. But until then, I hope you all stay safe and well, and look forward to catching up soon. Thank you very much for joining us today. Goodbye.